Would it inconvenience anyone if we sat again half an hour early tomorrow with a view to finishing half an hour early?
That's fine.
So 10 o'clock tomorrow. Thank you.
My Lords, there are a couple of points where I explain things to my Lords without giving you the references. Can I make good that omission? Loss of exclusivity that we talked about. I'm not going to ask you to turn it up, but just for your note, it's paras 420 to 424 of the judgment, pages 826 to 827. The steps that were demanded by Pfizer is dealt with in a long passage, paras 522 to 549. That starts on page 843. Again, I'm not going to ask my Lords to turn it up. The last thing I am going to ask my Lords to turn up is a reference that I should have given my Lords when we were dealing with the numbers. It's paragraph 564 on page 850. You get the same number, 17.4%, but the reason I draw my Lord's attention to it is for the very first sentence in 564. So I rely upon that for a submission that my learned friend just asserted to my Lords that, oh, there's infringement, please send it off to an inquiry. He didn't explain why he said there was infringement. My submission is that on the facts that you see in this judgment with all the steps that were taken, the numbers that you get, and with that finding in particular, on any test, the suggestion that there's infringement is untenable in my submission.
Well, wait a minute, there's a later passage, isn't there, where the judge says that there is some measure of infringement. I mean, the emphasis in the earlier passage seemed to me to be on the word substantial. Am I not right?
I think what my Lord might be thinking of is where he explains that a mere skinny label won't stop it.
That's right.
Yeah, but much more than a skinny label happened, my Lord. So if that's the passage that you're thinking of,
well, we'll have to look. But
can you remind me how long had your clients been marketing generics at the time before the trial? I think it was quite a short period.
it was definitely not years, but it was several.
It was months, I think, wasn't
months,
it?
Yes. And it wasn't just us. There were others that had been on the market as well.
Yes, but insofar as 564 is commenting on the relevant product, then there was a pretty short timescale by which the evidence could be gathered.
There was, but there are other factors. For instance, you may have seen reference to the fact that the software that had been changed took some time, but also a lot of the prescriptions were repeat prescriptions, and there was an issue at trial about the fact that it would have taken some time for people to go through doctors' surgeries' computers to actually change going forward, and that would have brought it down even more. That's the point I'm making to my Lords.
I see.
But there are all those factors.
But you can still say
exactly.
The findings of fact on which we have to operate are before us.
Exactly, and certainly it's unsatisfactory in my submission for my friend to just say, oh, it's obvious there's infringement, sending off to an inquiry on these findings of fact.
Well, I mean, we obviously have to light upon a general principle here, and we may have to test the principle by assessing more generally what the risk of prescription for patented indications is, because it may well affect the view that we take about what the test for infringement is. In some cases, perhaps not this one, there will be leakage.
That may be so.
On the facts, I see that you're entitled to say, because these are the facts in our case, there's no problem.
Exactly. I make that submission regardless of the test that
Yes.
my Lords alight on. Now, can I move to indirect infringement. As I understand it, well, there has always been one big problem for indirect infringement. Not only all the practical problems that I've been talking about, which apply equally here, what my lords were to conclude that there was infringement, that in particular, it makes pharmacists, as I understand it, direct infringers. And you'll have seen, I hope you'll have seen, that there was a supplementary bundle of interveners, which some of my lords gave permission to intervene in writing. Some of them are from pharmacists, and
we have seen
the
that.
great concern that they've expressed about that. But in terms of the analytical problem, by that I mean how on earth do you make it fit? It's the point that I tried to foreshadow earlier, in that it's a process of manufacture, the claim. And the idea that somebody further downstream puts the invention into effect when it is a process of manufacture is just not right. And what you're muddling up there is the actual treatment, which is not actually part of the claim, and it's deliberately not part of the claim because it's been framed in a way to try and avoid the prohibition on claiming it. And so you're muddling that up, and my friend is suggesting that, I think as I understand his case, he's saying that at least some of the steps in the process are carried out further down the line. And he disclaimed in argument a suggestion that, for instance, pharmacists infringe. And I just cannot understand how that can be so. And my lords know that certainly plenty of letters were written to pharmacists threatening infringement proceedings by this patentee. One of my lords read that section to me this morning from the judgment. I think it was my Lord Mance. And let's be absolutely clear, that is their case. Let me just show you the orders that were made in this case, just so that you understand what is contended for. So I want to show my lords volume 3, page 601. This is the order of Mr. Justice Arnold. So I'm core bundle 3. And my clients were concerned that statements that had been made suggested that there was going to be, or that Warner-Lambert were asserting, that 4 different categories of people would be infringers. And what I want to show you is paragraphs 1, 2, 3, and 4, because by the time of the end of the trial, they had backed off in terms of patients and doctors, and you see that there's a declaration by consent there. I actually invite my lords to note that.
Sorry, which page are you on?
Oh, I'm sorry, 602. Note that, because there is a hint, I think, of doctors putting the invention into effect in my friend's department. There's a declaration by consent that they don't infringe. And the declaration in relation to wholesalers and pharmacists was not by consent. There was a fight about that because it was asserted that those people would infringe. And moreover, if you go to 528 of the Court of Appeal order, and look at paragraph 8, because my lords will understand what happened in the Court of Appeal, that the validity appeal was dismissed, but the question of infringement, had there been a valid patent, was left open. And paragraph 8 is a modification to that declaration that was made, paragraphs 3 and 4 of Mr. Justice Arnold's order, by limiting it, by saying that it's only by reason of the invalidity of the claims identified below. And the purpose of that is that Warner-Lambert were maintaining a position to be able to argue that wholesalers and pharmacists do infringe. And certainly as we understand it, they're going to say that, or that was the position they were reserving in the Court of Appeal to be able to say, if the appeal to this court was successful. So it's always been my friend's case that pharmacists and wholesalers infringe, and perhaps the most important point to make about all of this is they are certainly going to think that they're liable for that when they see an argument like this, if it were to succeed. Now, how, we ask, can an invention which is a process of manufacture be put into effect after the box medicine is complete and passed through wholesalers and into, say, a corner shop pharmacist? The way in which that's done is an artificial argument in my submission to treat the claim as if it extends and reaches through past the act of manufacture. And I think they even say that some of the steps of the claim are carried on afterwards. Now, as I've already said to my lords, that is not right. The proper analysis of the claim is that it is a process claim for manufacture, and moreover, as I said to my lords earlier, you know that that's the way they're going to treat it when it comes to an ordinary full label case. They won't be treating the process extending through afterwards. They're going to say that a full label product is an infringement and, well, in fact, we know they're running that case because they're running a Section 61C case. And so, my lords, it is an artificial argument to suggest that the finished box of tablets is means for putting the invention into effect when the invention is a process for manufacturing a finished box of tablets. So that is the real problem with the Section 60 subsection 2 case, over and above the practicalities that it would have in terms of chilling effect. Now, my lord, I'm nearly at the end of what I want to cover. I've got the three foreign cases which my friend took you to. As I understood it, he did so not to suggest any particular approach was to be commended, but he made a submission simply to say, look, the foreign courts have considered both direct and indirect infringement provisions may be relevant for Swiss claims. And indeed, as I understand the position, for instance, the Dutch decision he took you to is a decision after the Court of Appeal in this case, and obviously simply setting out that test, although it doesn't specifically mention the Court of Appeal decision, but it's obviously a test. And that is a test that my learned friend actually disavows. He doesn't like Lord Justice Floyd's test in the last Court of Appeal hearing. So as I understand what's being said, it's simply saying, look, other courts think that there may be infringement under these two provisions. That doesn't really take my lords very far. The other point I specifically make about that particular case is you have to be a little bit careful about the nature of that invention. Let me just show you what I mean by that. Sorry, Authorities Volume 15, tab 178. Page 6405. And although it is a Swiss form claim of sorts, it's a very peculiar one because it includes detail both about the manner of the treatment. You go to 6397. See the claim about a third of the way down. It's quite a big fat paragraph. It's in quotes, the use of ribavirin. Do my lords have that? And you see it's quite a long claim. It had to be dual therapy with interferon alpha. The course had to be between 40 and 50 weeks. And importantly, it was limited to particular types of patient.
I'm going to have to, my volume 15 seems to have disappeared. We can get an extra one from...
I'll see if we've got a clean one. Here's a clean one.
No,
you've got it.
One, yeah. Thank you very much indeed. Very kind.
Let me start again. Could my lord turn up 6397?
Yes.
and it's the claim on the left-hand side.
Yeah.
And the point I'm making to my lord is that, yes, it's in the form of a Swiss form claim, but it's a very special type. It has all sorts of detail, both about the manner of treatment, dual therapy with interferon alpha, the course had to be between 40 and 50 weeks. And in particular, and importantly, it was limited to particular types of patient. You see, the last 4 lines is all about the patient. And you see the therapeutic indication, so what's on the label, begins at 6398. And as I've understood it, it's not really a skinny label in the sense we've been discussing at all, in the sense of it was for the indication, but it just that there weren't any instructions for the patients that were within the patented class.
Where do we find this on 6398?
If you go to 6398 at the bottom,
Right.
you see that what's set out are the instructions for naive patients, children, and previous treatment failure patients, which, as I understand it, are non-naive patients. And if you look at all of that, that is basically instructions for everybody other than the patients that are covered by the patent. You've just got to be a little bit careful about it. I can't say it's not a Swiss form claim, but it's certainly not the kind of Swiss form claim that we've been debating before my lords, where it's just an indication. The second of the 3 cases that my friend relied upon was a German case. It was an application for an interim injunction. It's in the same bundle at tab 180, 6425. You see that it's an application for a preliminary injunction from the very first paragraph on that page, second line. What you also see, if you go forward to paragraph 27 at the foot of 6427, you see that the application was dismissed on the grounds of it wasn't urgent. And so what we have here is something that hasn't been appealed to a higher court, and as an interim decision, and as my learned friend frankly accepted, is applying a different test to the German case law before. And the German case law before, in higher court, is basically the proposal of my Lord Sumption about manifest making up. And let me show you that. It's tab 173 in the same bundle, so page 6330. This was a case on...
For some mysterious reason, I think the estrogen blocker case was the one we given in German. For some mysterious reason, it appears as a Munich case rather than a Dusseldorf case.
Oh, well, that's important because you often have the same drugs tried in different courts in Germany.
Yeah.
That's likely to be a different decision.
No, it's the same. It's the same reference.
Oh, is it?
Yeah,
Well,
it's the same date and reference.
Maybe
It's
it's a
just
typo then.
somebody is confusing Munich and
Right.
Germany. And
Where was I? Yes, if we look at, this was a case on patentability, actually, the real case about, the real issue in this case was about the role of dosage recommendations. But if you look at paragraph 16 at the bottom of page 6335, you see the sentence bridging that page is not an element of preparation of substance for use in the treatment of disease, but rather follows it. So that actually makes the point that I was just making. It's not actually part of the process, it follows the process. So I get support for that proposition from here. But over the top of the page of 6366, you see...
6336?
Sorry, 6336. My Lord's quite right. You see what they consider usage claims, which is what they are calling the Swiss form claims here, to cover. Although a usage claim can be considered, i.e. you're allowed it for preparation of a particular substance for the treatment of disease, as is shown by a package insert enclosed in the sale of the medicament or usage instruction on the package, still no patent protection for pure dosage recommendation. So what they're saying is that you can get preparation claims, i.e. Swiss form claims, and they're explaining what they understand to be the scope of it. So, my lords, the interim German case that my friend relies upon is putting forward a very different approach to this case, which is actually Supreme Court, I think.
Yes, this is big here.
And the most that my friend can say is that in a future case it may be appealed up and considered such that the test in that other one has a hope, but it's a bit much in my submission to suggest that that's now the law. Now, in terms of indirect infringement, what we would commend is a French case, the Authorities Bundle, tab 1. And it's 6752.
Sorry, bundle?
16.
What was the tab number?
194. Apologies. And this is a pregabalin case. And the allegation in France was of indirect infringement, and you see that on 6970. And the passage that I rely upon, the short passage, is in the middle of the page, where it says the claims are considered as process claims and not product claims, such that the defendant companies...
Sorry, 6770.
I've got 6790.
6790.
Sorry, that's my...
Claims are considered as process claims.
Exactly, those two paragraphs, not product claims, such that the defendant companies cannot be charged with supply of means for permitting the use of the process in the French territory. It should be observed that the defendant companies import the pre-prepared medicinal product. It's already manufactured and don't supply any means for preparing the medicinal product. That's my case. And my friend took you to that Spanish case that just doesn't grapple with those issues. That, in my submission, is the correct approach.
Also, the paragraph below, beginning, contrary to the asserted case law of the EPO, that seems to be saying that you can't apply Section 60, subsection 2, effectively, to a Swiss form claim once the goods have actually been manufactured.
Yes.
Well, that logically follows from the fact that it's the manufacture with the relevant purpose. If it's already happened before the importation.
Exactly. It's a nonsense. And as I think I've said it a couple of times, it's inconsistent with saying that actually you can complain about the product under Section 61C. So, my Lord, that is the principled approach in my submission. I've come to the end of my note. Before I hand over to Mr. Saini, is there anything else that I can assist my Lords on?
Well, I gather that there's a bit of a disagreement going on between the Federal Patent Court and the German Supreme Court about what the legal principle is in respect of second use claims? Because I noticed that the estrogen blocker case is subsequent to the German Supreme Court case you showed us.
Well, there is definitely a prospect of it going up higher and being reconsidered.
Yes,
Yeah.
yes. But this is the one where they said that it would be downright off the mark to deduce XYZ from the Federal Supreme Court decision, and on one view, that's what might be deduced.
Perhaps.
Yes.
I just wanted my lords to see that there is other authority, and the one that my friend took you to is of limited value when it's an interim one, which wasn't appealed because it failed on urgency. Unless I can assist you any further, I'm going to hand over to my learned friend.
Thank you.
Lords, I'm going to address Mr. Mitchison and Lord Panic's submissions on construction first of all. And in relation to that issue, unlike some of the cases that come before this court, the construction issue in this case is rather an odd one, for a reason I'm going to explain, and it's actually very, very simple. And both courts below found the construction issue straightforward. And in my respectful submission, they were right to do so. So if we cut straight to the chase and look at the specification, which you will have in MS 922. And I want to first of all frame what I understand the dispute to be. And if we go to MS 927, and if the court could kindly go to the top of the right-hand page, under the number 10, you will see the third claim, which is use according to claim 1, where the pain is neuropathic pain. By a process of construction, the appellants say you've got to write into, where it says is neuropathic pain, write in peripheral neuropathic pain. That's essentially what they're saying one has to do. And we'll come to look at the rest of the specification in due course, but that's the debate. Now, it's rather an odd debate to be having, because as I'm going to show my lords, it is the primary position of the appellants that one doesn't do that. Their primary position is that this patent covers neuropathic pain of all types, central and peripheral, on its proper construction. And that's the basis of one of their appeals, in fact. They say they should have won on central as well. But it's rather an odd position to take, and I should just identify for my lords how odd it is by asking my lords to take up just a small part of their written case at page MS 146. This is their original written case. If I can please pick it up at paragraph 8. However, importantly, in relation to claim 3, which is what we've been looking at, pregabalin is in fact effective to treat both peripheral and central neuropathic pain. Indeed, it is licensed to be used to treat those conditions across Europe. Therefore, even for those claims of the patent that could be read as covering central neuropathic pain, the patent discloses the use of pregabalin that were inventive and which do in fact work.
That's an appeal to after acquired knowledge.
It is, but if one goes on to the next paragraph, that's the crucial point. The person skilled in the art reading the patent is therefore able to perform the invention in claim 3 fully across its scope. We'll just stop there for the moment, please. By scope in that sentence, they mean able to perform the invention in claim 3 according to its proper construction. Its proper construction being it covers both central and peripheral. And then they go on to say, yet thus far the courts in this jurisdiction, but no other court applying the EPC, have held that claim 3 is invalid on the basis that the treatment of central neuropathic pain was not plausible or credible. So we have this odd position, that's why I say this is rather strange, where they are marketing the product, based upon this patent for central neuropathic
No,
pain.
but that's after acquired behaviour.
That's right.
It's not licensed till later.
Absolutely, but
I mean, we're not going to construe this.
I completely agree with that. But then one needs to carry on to see that we regard that as being, that's their case on construction as well.
It isn't. They've got an alternative case
Well,
of construction.
I appreciate that, my lord, but then if one looks at the alternative, my lord's absolutely right. Let's look at the alternative claim, which is in paragraph 11. In the alternative, the appellant contends that construing the supposedly invalid claims to cover the material that had been held implausible, i.e. central neuropathic pain, was an error. So the primary case as a matter of construction is that central is covered.
Yes.
The secondary case is that if central is not covered because of this plausibility attack, then please construe claim 3 as being limited to peripheral. That's why I say this is a rather odd claim, because normally one has two opposing constructions and the court has to resolve the fight. But we have happily, in this case, Mr. Justice Arnold, Lord Justice Floyd and the other members of the Court of Appeal, my clients and the appellants all agreeing on a particular construction. The alternative construction only comes into place if they can show that because if the claim is construed according to its natural construction, it becomes invalid, then you should put a wider in.
You're trying to apply a squeeze, which I at least would require persuading was necessarily one to which they should be held.
Well, I'm not saying they should be...
The exercise we're engaged in is of looking at the document,
Indeed.
Considering the surrounding circumstances to some extent, which don't include subsequent licensing or use, and construing it. And if we came to a conclusion that it didn't include central neuropathic pain, it wouldn't matter whether that was because it hadn't been made plausible or not. The lack of implausibility is really possibly a fallback alternative to this second way of looking at it, or a reinforcing consideration if it's legitimate to apply the principle of things should survive rather than perish in this context at all.
My submission was just a modest one, my lord. Nothing complicated, simply that everyone has agreed.
Well, everyone's agreed about construction.
But it's important, my lord, because what's going to happen, we're going to go look back at the patent in a moment. What's happening is they want the court to write in something because of, as my Lord Thompson observed yesterday, because of what happened in a long trial, where it emerged after a long trial that there was a successful validity attack as regards plausibility on one aspect of the claim. They're saying that should be a factor which influences the court in this paragraph 11 approach in construing the document.
Was it an alternative case they ran at trial?
Well, this is this. I'm going to show my lord what happened. So their case at trial is that both types of claim are included. They make no distinction.
And they didn't run an alternative case?
No. What then happens, and this is part of the...
I think there's
well, I'm going to explain. I'm going to explain what happens. As Mr. Justice Arnold observed, and as Lord Justice Floyd observed in the Court of Appeal, this alternative case appeared rather oddly just in the cross-examination of Dr. Scadding. Very late on in the case, Mr. Mitchison, no doubt appreciating that he had a problem with the central neuropathic pain aspect of the case, decided, and this is what was described as skillful cross-examination by Lord Justice Floyd, to try and introduce this alternative case via cross-examination. So it emerges very, very late in the day, and we're going to look at those passages. But that's my Lord may say, well, that's not helping me in any way, any of this. But it is relevant to this extent, because when we're construing language, everyone is agreed what the language means, but it's only if there is a successful plausibility attack maintained, they say you've got to construe the language in a different way.
All that they're doing is making submissions on different hypotheses as to what the court may consider on another point.
Indeed.
I mean, this is completely routine. It's the bunter defence. I did not steal your orange. Alternatively, it was a bitter and tasteless orange.
If I can go back to the specification itself,
Well, I think that's probably the starting point.
and there are a large number of cases on construing patents, but I'm going to identify just two straightforward ones in the same bundle. And that's Authorities Bundle 12, sorry, Authorities Bundle 2. And the first case I draw the court's attention to is MS 1755, Dyson Appliances case. And it's page 1762, the judgment of Lord Justice Aldous. Paragraph 12, the reason I show this is because this is an explanation of what, if anything, had changed following Article 69 and the protocol on interpretation of Article 69. And it's essentially paragraphs 12 to 13 which are relevant. But if one looks at paragraph 12 and the quote at 18, it says Section 125 of that Act provides that an invention shall be specified in the claim as interpreted by the description in any drawings and shall be determined accordingly. So the first thing the court is looking at is the claim. So it's the claims that you're going to be interpreting, and then you look at the description and drawings as aids to interpretation. And what is being said at paragraph 13 is that essentially the approach being you look at the language, it's a matter of law for the court, and you look at technical terms as part of the factual matrix or common general knowledge, one might call that. While we're in this bundle, just as a matter of doing it quickly, if one could go to divider 23 to MS 2019, there's an earlier judgment of Lord Justice Staunton in a case called Glaverbell. And if I'd ask the court please to go to page 268 of that.
So, MS page?
To MS 2032. Again, we have propositions which we say represent the correct approach, propositions 1 to 5. And again, one has, at paragraph 1, quite familiar principles one sees in other areas of law about interpretation of written documents as a question of law. Then at paragraph 2, common general knowledge. And then at paragraph 3, a statement that the court should admit evidence of the meaning of technical terms. And that's going to be relevant in a moment when we come to look at parts of the specification. Happily, this patent, unlike some, is in relatively non-technical language. But when there is technical language, one can look at expert evidence. And just, I won't ask the court to read it now, but if one goes just on page 269 to line 30 to the reference to Lord Diplock in Catnick components, and over the page, there Lord Justice Staunton is saying that the semantic approach that one used to once adopt to contracts no longer applies. And just for the court's note, without burdening you with further authorities, going back to page 1762 in the Dyson Appliances case, where Lord Justice Aldous was quoting from the Wheatley and drill safe case, my Lord, Lord Mance may recall that my Lord was a party to the Wheatley and drill safe case.
I do indeed.
And
I think, in fact,
think my
Lord
Lord
Justice
and-
Aldous was, in fact, dissenting.
Indeed, I think my Lord and Lord Justice Ellie dissented with Lord Justice Aldous in the minority. But what my Lord did say in that case, and this is an important...
Not on the law, he didn't dissent there.
No, not on the law, just on the issue of injury. But what my Lord did say, which is of relevance in that case, is that what Lord Diplock said in Catnic Components quite long ago, and what is said in the protocol, has for a long time represented the approach of the English courts to construction of both contracts and other written documents. I don't want to hand it up necessarily unless the court wants to. We've got the Wheatley case here. But just stopping there for the moment and taking stock, the primary task of the court is to interpret the language used. It's an English language, and subject to technical terms, the task of the court is to apply the principles of the English language. And that's very important in this case if one goes back to the specification. So we can perhaps put away those authorities. I've taken them rather quickly, but there's nothing in them which is particularly surprising. What one does not see in the recent authorities is any suggestion that one should be adopting something like a validating construction, or that one should be trying to resolve ambiguities one way or another. We say the start and the end of the construction exercise is what's required by the protocol, which has been set out. And the protocol, as my Lord Justice Mance observed in the Wheatley case, just represents the English approach to construing documents anyway.
Well, wait a minute. Haven't we rather gone back on that in activists? I say gone back on it. We've possibly corrected a misapprehension in activists and Eli Lilly.
That's on a different issue. That's on a different issue, my Lord.
That's on the second part of the program.
Absolutely,
Yeah,
my Lord,
yes,
my Lord has
yeah,
it. So,
right.
in terms of the pure construction issues, which is what we're dealing with in this case, then the start and the end is Article 69.
Yeah.
And no one doubts that going back to Lord Diplock, at least, and one can actually probably go back much earlier than Catnic Components, the approach to construing documents is long established. No semantic analysis, it's purposive. Nothing more than that. And it's then necessary to go back to the specification. We put away those authorities, please. One goes back to the specification. And I've shown the Lords that under section 125 of the Act, what the court's got to look at is the claims, and you interpret the claims with the assistance of the description and drawings. So if we look at this, before we look at the detail, the description appears at paragraph 001 on MS 923, and it carries on for some pages up to the claims at paragraph 0033 at MS 927. So one needs to look at all of that. But the focus is on, what one is the claim. Now, what I'm going to submit the court gets from this document, if one looks at the specifics, is that the draftsman, as a matter of plain language, was claiming a monopoly as regards this pharmaceutical composition for the treating of all types of pain, every type of pain under the sun. And if one looks first of all at claim 1, So it's the use there of the composition for the preparation of a pharmaceutical composition for treating pain. Now, one doesn't need to be a scientist to know what pain is, but there was a very active debate before Mr. Justice Arnold, and you haven't seen this part of the judgment yet, as to what was Claim 1 covering. My clients were saying pain is pain. Every type of pain. Nothing is different. The appellants were not accepting that. They're saying, no, this is a special scientific kind of pain. And as a matter of fact, based upon evidence, Mr. Justice Arnold rejected the case of the appellants and accepted our case, which is pain, all pain. Now, I just need to show you that, so we can, if we can go back, please, in this same bundle to page 714 at paragraph 244 of the judgment of Mr. Justice Arnold. And between 243 and 251, Mr. Justice Arnold resolves this dispute as a matter of construction. And the two sides of the argument being, my clients, see paragraph 244, IASP definition, pain is all types of pain. And then by contrast, based upon a particular scientific understanding, the appellants at 245 were arguing a different construction. And at 251, Mr. Justice Arnold concluded we were right. Now that's quite important because that's essentially, I suppose it's a question of construction. There's no appeal against that. There was no appeal against that in the Court of Appeal nor before my lords. And one could say, in a sense, that's a factual finding because the judge there is deciding on the basis of evidence what a skilled person would understand that to mean. But in a sense, it doesn't matter. The first point is that this court should proceed on the basis that in Claim 1, the patentee wants to claim a monopoly for all types of pain, everything. Now, where this is going is that not only are we going to have to write something into Claim 3 to write in peripheral before neuropathic pain, we're also going to have to write some wording into Claim 1, which is, I am claiming a monopoly for all types of pain, open brackets, save insofar as it is central neuropathic pain. So that's something else that needs to be written into there.
Why do you have to write into Claim 1?
Because on its pain interpretation, just as a matter of...
No, it covers everything, but that doesn't mean that Clause 3 has to cover everything. By definition, it doesn't. It's clearly limited to something.
Well, I'm going to come back to Clause 3 in a moment, but I'm just dealing with, we're construing this specification as a whole.
Yes.
What one wants to do. So one needs to start with Claim 1. Claim 1 covers all kinds of pain.
Yes.
And on Mr. Justice Arnold's findings, there is nothing to be excised from there. So
Yes.
it would cover, unless one writes some exclusory word again,
Right.
it will cover central neuropathic pain.
Right.
And then, if one looks at the other, I'm going to skip over Claim 3 because we're going to focus on that in a bit more detail. If one goes to the other claims, and I hope what I'm saying is not in dispute, but if one looks at Claim 4, which is use according to Claim 1 where the pain is cancer pain.
No.
The evidence before the judge wasn't in dispute, that cancer pain could be either central neuropathic pain or peripheral neuropathic pain. Similarly, if one goes down these other...
The other types of pain listed in 2 to 14 aren't the only types of pain, are they?
No.
No, well,
But the ones with
well,
those,
that being so, why should one construe any one of them as being limited in any way?
well,
I mean, if the
one
intention had
shouldn't.
been...
One shouldn't.
No.
Our submission is that each of these either diseases or pain states...
Sorry, unlimited. I meant.
Indeed, yeah. Each of these pain states can can manifest itself in either central or peripheral neuropathic pain. And in fact, just so that the court has this, if one looks at paragraph 6, phantom limb pain, there was a finding of fact made by Mr. Justice Arnold, which the appellants tried to disturb on appeal but failed, that phantom limb pain that's actually a form of central neuropathic pain.
Sorry, that it is.
It is a form of central neuropathic pain. So the reason that this is relevant...
It is or it isn't a form?
Is.
It is?
It is.
And it's not a form of peripheral?
No.
I see, yeah. So it's not quite right to say that each of them can manifest itself in central or.
Well,
that one is
that's why
solely,
I pulled that one out. But then one has, for example, at 13, you also want to claim one where the pain is idiopathic pain. So we don't know where the pain's coming from. So the reason I make this submission is that Mr. Mitchison said yesterday he didn't understand Lord Justice Floyd's reasoning when he said that one's not to read Claim 3 restrictively, because the draftsman here was trying to claim every type of pain. He was being expansive. Now, so far I've just looked at the claims, but the position from the appellants becomes worse, not better, when one looks at the description. And if one goes back then to page MS 923, please, and to 003, paragraph 003, the submission I'm going to make is that if one looks at paragraph 003, and one doesn't need to be a scientist to say this, what's being described there is an invention to cover all pain types. So if one looks at it, it says the instant invention is a method of using a compound identified below in the treatment of pain, especially for treatment of chronic pain disorders. Then, such disorders include, but are not limited to. Now, can I emphasize the word but are not limited to, because we're going to see that appearing, I think, at least another 4 times. This is the language used, if one is using the English language according to its ordinary sense, by someone who's trying to make sure he's not limiting himself. Such disorders include, but are not limited to, inflammatory pain, post-operative pain, osteoarthritis pain associated with metastatic cancer, trigeminal neuralgia, acute hepatic and post-hepatic neuralgia, diabetic neuropathy, causalgia, brachial plexus avulsion, occipital neuralgia, reflex sympathetic dystrophy, fibromyalgia, gout, phantom limb pain, burn pain, and other forms of neuralgic, neuropathic, and idiopathic pain syndromes. So you will have noticed a specific reference to neuropathic pain there. No indication that that reference to neuropathic pain was confined to neuropathic pain of a peripheral character. So everything is included. Everything that is referred to there expressly, plus other pain states which will be known about but aren't expressly referred to. So then one goes to paragraph 006 at page 924. And it's in the middle of this that one finds the high point of Mr. Mitchison's case. But in fact, if you look at paragraph 0006, it doesn't help him, because it says the instant invention is a method of using this particular product or acceptable sort thereof as an analgesic in the treatment of pain as listed above. So, if one just stops there, one is being told, go back, please, to 0003, which, as I've already shown the court, includes all forms of neuropathic pain, because this draftsman doesn't want anything to be missed. So we've already got central neuropathic pain, in addition to peripheral. Then we have next, going back to paragraph 6, to the fourth line where I stopped after listed above, pain such as inflammatory pain, neuropathic pain, stop there, so we've got again a reference to neuropathic pain, cancer pain, post-operative pain, and idiopathic pain, which is pain of an unknown origin, for example, phantom limb pain, are included especially. Again, especially is wording which is non-limiting. And then we have this sentence which is being asked to bear a hell of a lot of weight. Neuropathic pain is caused by injury or infection of peripheral sensory nerves. One stops there. The entirety of the claim on construction is based upon this sentence as being an indication that the draftsman was intending to confine, by way of a definition, confine neuropathic pain to pain caused by injury or infection of peripheral sensory nerves. Now, we'll come back to that wording, but again, this draftsman is so worried that I might not be claiming everything. He then immediately carries on. It includes, but is not limited to, pain from peripheral nerve trauma. There's a whole range of further conditions. So, a person who understands the English language reading this will be saying that he has given a description of a form of neuropathic pain, which is true. Neuropathic pain is caused by injury or infection of peripheral sensory nerves. That's true, no one is doubting that. Then he's going on to give the more expansive wording, just in case anyone thinks he is being limiting. It includes, but is not limited to pain, and then he carries on.
Well, is he in this sentence, the one that starts in it includes, is he saying that neuropathic pain is not limited to peripheral neuropathic pain, or is he saying that the larger category is not limited to peripheral neuropathic pain because it also includes herpes, diabetes mellitus, corsalgia, etc.?
We read it as the formal, which is that when he refers to it, he's talking about neuropathic pain.
Are all the examples that follow illustrations of peripheral neuropathic pain?
Not limb amputation.
No, they are mixed.
Right.
Limb amputation, I thought you said a moment ago,
Indeed,
was in fact
that's
just central.
Classic example. Phantom limb pain is a classic example based upon a finding of fact of central. And then we have.
So, I mean, when you say the former, I mean.
I'm sorry, it was the it.
Did you mean the latter?
By the it. And I was saying the it is neuropathic pain. So neuropathic, for it one could write in neuropathic pain includes, but is not limited to.
Well, it doesn't include some of these things.
Well,
Limb amputation,
no, I believe,
for instance.
Well,
so it doesn't include
well,
those.
It does include neuropathic, it does include limb amputation.
That suggests that
No.
it is not referring to
Lord,
neuropathic pain. I mean, this is, I think, a point in your favour, isn't it? Which is why I was a bit surprised for you to accept the former and more limited interpretation that I put to you, which was, I understood, your opponent's interpretation. As I understand it, because some, at least one, but I think more than one, of the list there are examples of something that can't be neuropathic pain, the it has got to refer to a broader category than just neuropathic pain.
Well, I wasn't understanding my Lord's question. My Lord's quite right.
Clearly, limb amputation most naturally refers to the sentence the pre-penultimate sentence, not the one beginning neuropathic pain is caused, but the one beginning pain such as inflammatory pain.
Pain generally.
Pain. No, because that includes post-operative pain and limb amputation. Is that not?
That could be, indeed, yes.
Phantom limb pain.
And phantom limb pain, yes, it goes on.
Included especially.
Are included especially. So, I mean, and since neuropathic pain is one of the items in that second sentence, the it must refer to the second sentence rather than to the third.
Yes, my Lord. If one carries...
So, I mean, which way that cuts is a
Well-
matter for further discussion. Now
Well-
we've clarified.
Indeed. But if one carries on, though, I believe it was common ground yesterday that these conditions that one sees here, in the it includes, they are not exclusively peripheral.
Are they exclusive? But
No, they're mixed. I
they're
think it's fair to
mixed,
say
but-
they are mixed.
are you accepting that they're not exclusively neuropathic?
Well,
You're asserting that. In relation to limb amputation, you assert that, don't you?
It's odd the way it's structured, because you get in sentence 3 neuropathic pain and it. Sentence 4, sentence 5 starts with neuropathic pain. The next sentence is neuropathic pain,
indeed.
as if the whole thing is discussing neuropathic pain. And the it
I'm
would
going to
be-
show my lords. I'm going to show my lords what Dr. Scadding said, whose evidence was accepted about which categories are included within neuropathic pain.
Yes, and can I ask also, and you've told us that phantom limb pain is a form of central neuropathic pain, but in the sentence that refers to phantom limb pain, it seems to be given as an example of idiopathic pain.
Yes. Which is pain.
Idiopathic pain, which is pain of unknown origin, for example, phantom limb pain.
Indeed, that's right. But then the judge made a finding, based on the evidence, that a physician would regard that as being central.
No, but wait a minute. We're talking in terms of not what a physician would regard, but what this says. The reader, the skilled reader of this document, if it regards it as the baker's dozen type of different meaning, then on the face of it, it regards it as idiopathic pain.
If I can just carry on down the page and then come back to this list, carry on down paragraph 6 to the third line from the bottom after vasculitis. Neuropathic pain is also caused by nerve damage from chronic alcoholism, human immunodeficiency virus infection, hypothyroidism or vitamin deficiencies. Now, again, vitamin deficiencies we're going to look at. Vitamin deficiencies was identified as a form of central neuropathic pain. I'm going to show you some evidence about that. But again, with a hat on which suggests he doesn't want to miss anything, please look at the next sentence. Neuropathic pain includes, but is not limited to, pain caused by nerve injury, such as, for example, the pain diabetics suffer from. Now, one has to stand back from both paragraph 6 and paragraph 3 and say, was the draftsman here intending to exclude peripheral neuropathic pain? Bearing in mind, he never uses the word peripheral neuropathic pain. He uses the wording
To exclude central neuropathic.
to exclude central. Yes. Sorry, my lord.
Intending to exclude central neuropathic.
Indeed.
And you say not, because some of the examples are examples of central neuropathic pain.
Simple as that. Simple as that. And also, one bears in mind paragraph 3, which carried weight with the courts below, which is that the intention that one gets from paragraph 3 is that this draftsman wants to include everything.
Well, I mean, the question is not whether he wants to include everything, but whether he's succeeded in it.
Well, he certainly has succeeded. If one reads paragraph 3, he has certainly succeeded in showing, in wanting to include neuropathic pain generally, because one sees that referred to.
The question which the judge posed was the sentence neuropathic pain is caused by injury or infection of peripheral sensory nerves. The question he asked himself is that descriptive, in which case it's just a true statement, or is it definitional, in which case it's intended to exclude anything, any neuropathic pain that is not peripheral?
Correct. That's the essential issue.
And you submit that that's the right question to ask and the right answer.
Indeed, indeed.
Where's the evidence, it would be useful to have, that vitamin deficiencies are a form of central?
I'm going to show you that now because the evidence...
That's the only one, is it, in that fourth sentence?
I can show you the evidence before the trial judge, which he referred to in both and the Court of Appeal referred to on various occasions.
Chronic alcoholism peripheral?
I'm sorry, my lord?
Is chronic alcoholism a form of peripheral neuropathic pain, or is that central?
I'll have to take instructions on that, but I can't give you an answer immediately.
And is pain from limb amputation a wider category than phantom limb pain?
Yeah, it might be.
Well, there are two. There's limb amputation, which might be the pain immediately caused,
Yes, right.
which I think my lord may have a minor distinction that Ms. Justice Arnold made, and then the subsequent pain, which is the phantom limb pain.
But that seems to be, you see, phantom limb pain, they can't be describing as neuropathic pain because they've just described it as idiopathic pain. So limb amputation looks to be the immediate pain.
Essentially a form of post-operative pain, or it could be post-traumatic pain.
But let's go through the ones
So
which you say.
If one goes to the evidence that the judge referred to in Dr. Scadding's report, it's in Appendix Part 2, page 1029.
This is Dr. Scadding's report, is it?
That's right. And he set out here the causes of neuropathic pain.
Amputation is among those, so he's making the same point as...
That's right, but one sees on the
Lord
far
Reed.
right.
Trauma,
One sees, that's right, on the far right, one sees under E, phantom limb pain. So he's distinguishing there.
Yes, it's distinguished from amputation, yeah.
And one sees under, so just to make it clear, if one can keep a finger in there, and just go, please, ahead to page 1163, where he describes...
Do we find vitamin deficiency on this list?
Yes.
yes, under the spinal cord, and also...
I see, it's spinal cord,
And
part,
polyneuropathies in column 1.
part H.
But just so that I'm showing my lord's...
But it's also under peripheral nerve, isn't it?
Yes.
Correct, yes.
E and F of polyneuropathies.
Yes, it depends on what kind of vitamin deficiency.
Indeed, absolutely.
Right.
So, I mean, so
Yeah, I mean, I suppose one could. Should one read vitamin deficiencies in paragraph 6 of the claim as necessarily meaning every kind of vitamin deficiency?
Well, it's certainly put in deficiencies in general terms. But just so that you know, I'm going to give you a cross-reference to page 1163. But at page 1163 of this bundle, just under 7.5, just above 7.5, 4 lines, he says, other types of neuropathic pain where the primary cause
Whose report is this?
I'm so sorry, this is a further report of Dr. Scadding. But I'm just showing you this so that one can understand what's in Appendix 1 at page 1029. Just above 7.5, 4 lines, he says, other types of neuropathic pain where the primary cause is a lesion in the central nervous system and which the skilled clinician would not expect to possess a central sensitization component are listed in Appendix 1 to my first report under the heading spinal cord, brainstem and brain. So if one goes back to page 1029, those 3 categories at the top, spinal cord, brainstem and brain, He's identifying those as ones where there is a primary cause is a lesion in the central nervous system.
And, I mean, dorsal root ganglion and spinal root, that's the amplification effect.
Sorry, my lord, the
Dorsal root ganglion and spinal root, that's the process of amplifying the peripheral.
I'm told that that's just where the damage is.
See it?
It's where it happens to be
Yes.
amplified when it is amplified.
Indeed.
Yes, I follow.
But if I just stop there for a moment, one needs to bear in mind as well that one must not lose sight of paragraph 3, where all types of pain are being considered, with a list which does not seek to exclude anything. Going back to the specification we were looking at earlier.
Yeah. So for example, in 3, trigeminal neuralgia, I see, for example, appears under dorsal root ganglion and spinal root.
Right.
So does plexus avulsion, which I think
Yeah.
they call something else.
Yes.
Is dorsal root
Central.
central?
No.
No. It's-
No? Oh, I thought it was.
So central is the last 3.
Yes.
Indeed.
Oh, right, okay.
How odd. Spinal root would be central.
Sorry, I was making the point on paragraph 3. Paragraph 3 is claiming all types of pain.
It's a question of which is the tail and which is the dog, I suppose.
Indeed. But it's a very odd approach to construction to say that when someone is saying, I'm claiming these types of pain, but these are not the limited ones, we're going to read in a limitation.
I mean, you say the critical question whether this is torrential drafting or a very careful
Indeed.
list with intentional gaps.
That's in a sense, it's a kind of binary issue. Is this person trying to include everything and being cautious, so cautious that he keeps saying, but not limited to? What does that indicate to the reader of English? It indicates to the reader of English that what he is specifying there is not meant to be a comprehensive list. That's why we say both the trial judge and Lord Justice Floyd found it quite an easy issue. But it's important then to appreciate how the alternative construction arose. And if I can ask the court please to go to the judgment of Mr. Justice Arnold, back in Core Volume Part 3.
Page.
Sorry, my lord, I'm just finding my page reference. It's summarised in the Court of Appeals judgment.
At page?
One goes to page 1, MS 588. It's paragraph 176. And that is referring back to, and he says it was raised at a late stage, this amendment argument. It's referring back to Lord Justice Floyd's summary of what had happened in the proceedings below. So if one goes...
Paragraph 257 of Mr. Justice Arnold, where he states that the matter was first raised on the cross-examination of Dr. Scadding. Is that the reference you're looking for?
That's right, my lord.
It's MS 796.
Grateful.
And therefore wasn't put to Professor Wood.
Indeed. So we don't have other witnesses, in particular the witnesses of the appellants having been asked about this. It's raised as a question.
Well, it's either fair or not, and we have to take the evidence as it is, don't we? I suppose your side could have applied to have your witnesses cross-examined if you felt it was unfair.
Indeed, well, it's not a question of unfairness, it's a question of, it's an afterthought. That may not be a problem because, you know, often one thinks of construction arguments in the course of a case. That happens at any point in time. But it's why I said at the outset that up to that point in time, and indeed up to this point in time, it remains the primary case of the appellants that one has to construe Claim 3 to include central neuropathic pain, and it's valid for central neuropathic pain.
And presumably their expert evidence was directed to showing that it...
They made no distinction. So
central is just not referred to?
Indeed, indeed. So, okay. My lords, have already got this point back from what Mr. Speck was saying, that the evidence of their experts was not getting into any detail on the difference between peripheral and central. It was limited to the issue of central sensitization, which they said was the unifying feature.
Yeah. The unifying feature with inflammatory.
Indeed. Absolutely. So the reason I mention when the issue arose is because it is, as we understand it, still the case of the appellants, the primary case, that one should construe, it's a question of construction, one should construe Claim 3 as extending to central pain. If that's wrong, then no doubt my friend will tell me tomorrow. That's why we have the alternative argument. And the alternative argument, which I'm going to address now, is that if, as a matter of language, Claim 3 is not to be limited.
I thought that the submission that you've been making so far was precisely that it was not limited to peripheral pain. That's your primary,
covers everything.
Your primary case, never mind what theirs is that it covers everything.
Indeed.
And that's too wide.
Indeed. And that follows from the reading of the specification, and in particular the global point, which is that the draftsman doesn't want to exclude anything, he wants to include everything. And that comes not only from paragraph 3 and paragraph 6, but also comes from where I started, the first claim, all types of pain.
Yeah, well, personally, I find I may be being old-fashioned, and maybe I'm never sat on a jury, but I find it helpful to look at the argument in those terms by reference to the words and conventional methods of construction, and it seems to me to mix it up with the way the case has developed is not entirely helpful. I mean, It's
Well-
maybe prejudicial, but it's...
Well, my Lord, I'm not trying to be prejudicial, but that's why I said at the outset that this is an odd kind of construction dispute.
Yeah, well,
So-
it is odd, but then people sometimes do somersaults. And,
Indeed. So, my Lord has our argument that just construe this patent according to ordinary English language,
No.
and the draftsman wants to include everything, not exclude anything, and therefore both Mr. Justice Arnold and the Court of Appeal were plainly right. And insofar as Mr. Mitchison says he doesn't understand Lord Justice Floyd's point, which is that he says that the draftsman was clearly intending to be very, very wide. How does that support the argument against him? It's obvious with respect. So it's no more complicated than that. What's interesting is that had the draftsman intended paragraph 6, those crucial words in paragraph 6, which are the start and the end of Mr. Mitchison's arguments, had he intended those to be a definition, he would have perhaps used some clearer language. He would have said, for the avoidance of doubt. I know above I have described neuropathic pain generally, but I'm confining the scope of my monopoly as regards neuropathic pain in this case to peripheral neuropathic pain only. That's essentially what he's saying is achieved by paragraph 6. But we are, with respect, a million miles away from that.
I mean, the big things, just looking at the very helpful table which Dr. Scanning produced, 1209, if it's confined to peripheral, the big things which have been omitted, which this patent doesn't purport to, on that construction, to address, would be what?
Strokes.
Tumour, stroke, possibly multiple sclerosis.
Cancer, a range of cancer pains.
Cancer of the brain.
So we've got spinal hemorrhage, tumour, yes. A large number of, spinal cord injury, a large number of recognised pain states.
Thank you.
I see Mr. Justice Arnold found that phantom limb pain and fibromyalgia pain, which were claimed, were conditions regarded as involving central neuropathic pain.
That's right. So, but I should explain what happened next, is that those two factual findings were the subject of an appeal. So the appellants sought to appeal Mr. Justice Arnold's findings both as regards fibromyalgia and phantom pain. They succeeded on fibromyalgia, but failed on phantom pain.
And the point that can be made against you on phantom pain is the one we've already discussed.
Exactly, it appears elsewhere as unknown
defined
origin.
as idiopathic, yeah,
Okay.
for present purposes, yeah. But really, I mean, it's spinal stroke. You've got enough other things
Indeed.
which you say are significant. Why
Absolutely.
should they give them up? And they in fact, the hunch was right because they are in fact addressed.
Indeed.
Yeah.
And there's one further point as well, which is I need to refer the court to the IASP conclusions. That's in other words, the professional definition of neuropathic pain. And if one goes to page MS 796, under claim 3, page 257, this is an important passage, which I don't think the court's seen yet, which is just looking at claim 3 itself, just looking at claim 3. What does it include? If I can just read the first paragraph, please. Claim 3 is limited to neuropathic pain. Warner-Lambert contends that neuropathic pain would be interpreted by the skill team as peripheral neuropathic pain and hence as excluding central neuropathic pain. Strikingly, this contention was not foreshadowed in any of Warner-Lambert's evidence or in its skeleton argument for trial and was first raised during the cross-examination of Dr. Scadding. Mylan and activists dispute this interpretation and contend that neuropathic pain should be interpreted as encompassing both types of pain.
He then gives 4 reasons for his conclusion.
Indeed. So, again, that's a finding of fact, not disturbing the Court of Appeal and no basis to interfere with it in this court, which is the skilled person looking at claim 3 would use the IASP definition. I would emphasise, and the court will...
Well, is that can you put it as high as that? The skilled person would construe this in a particular way?
Well, that's the skilled person is the interpreter, and both sides are arguing as to what the skilled person would understand. But what's crucial, my lord, is paragraph 259, because this is not just one side's evidence. This was the evidence of both sides. So, secondly, the IASP definition encompassed both peripheral and central neuropathic pain. Professor Wolf accepted that the purpose of the IASP classification was to provide clear and precise definitions. Professor Claw's evidence was that the IASP task force lagged some 5 to 10 years behind the field. Thus, definitions adopted by the IASP had often been in common use for a number of years beforehand. Furthermore, he was clear, this is the expert of the other side, he was clear that the term neuropathic pain encompassed central pain. And then one sees that the passage that you may be familiar with at 260 about paragraph 6, which is what I've said is the high point of Mr. Mitchison's submissions.
Paragraph 260.
That's right.
So he is implicitly adopting the descriptive approach to that sentence, not the definitional one.
Yes, but it's very difficult to treat sentence 3 as definitional when sentence 5 gives further specification of what is included within neuropathic pain, which is a point in your favour.
So, Lord, so far, we've just been looking at the specification, and our case is that, just as a matter of language, looking at the specification as a whole, it's clear that the neuropathic pain covered both central and peripheral.
Why does that sentence go further, as my lord,
Sorry, my lord.
just put to you? Neuropathic pain is also caused...
Sorry, my lord, which sentence is my lord?
Well, I was wondering which sentence...
Sentence 5, neuropathic pain is also caused by
nerve damage from...
Indeed.
And then nerve damage is peripheral nerve damage, isn't it?
Well, not necessarily, no. That's, I think, the point.
I see.
So, again, that's wide wording, because that's unqualified there. Nerve injury.
It depends whether sentence... Yeah, it's difficult, isn't it?
What's happening
whether
here,
sentence 5 is tacked onto sentence 4.
What's happening here, my
Sentence 3.
lord, is that we are doing exactly what all of the cases say we shouldn't be doing, which is we are getting into syntactical analysis and missing the big picture, which is the big picture is what's in paragraph 3 and claim 1, which is I want to claim all pain, and we are now trying to interpret this perhaps as a charter party or a more technical document, but in fact it's absolutely clear that the draftsman wants to include all forms of pain.
I mean, are you submitting that the mere fact that it's difficult to work out what paragraph 6 does mean is an indication of insufficient clarity?
Sorry, my lord, that...
Are you submitting that the mere fact that this is obscure and that one has to spend half an hour arguing about what it means makes it difficult for them to suggest that it has a narrower meaning for the purposes of construing the claim?
So it also strongly suggests that's not a definition section there in paragraph 6, because one could spend a long time arguing about what the definition includes and doesn't include.
What I was suggesting to you was that if one, the fifth sentence follows on from the fourth, once one recognises that the fourth is confined to peripheral sensory nerve damage, so is the fifth. It says also caused by nerve damage from these other things, which then leads to a possible problem with vitamin deficiencies, but since it's quite clear that they can be caused by peripheral nerve damage, that may have been all they were thinking of, having, in the light of the third sentence, if one reads it as definitional, and confine themselves to peripheral matters. That's the argument which might be run against you.
Yes. But again, one also has to bear in mind what's
As the sixth sentence, I'm sorry to interrupt, is also, I see, caused by nerve.
Indeed. So again, there is no confinement there to peripheral nerves. There is no reason why neuropathic pain includes, but not limited to, pain caused by nerve injury. There can be nerve injury to the central nervous system, not just peripheral sensory nerves?
Well, yes, that's another interesting question. The fourth sentence has the word peripheral before nerve, and the fifth and sixth either draw
Generally
a subtle
use the word-
distinction, or else just being not wishing to repeat themselves and assuming it's implied doesn't.
So, Lord, you have our submission as to what the construction is as a matter of language. I now turn to what I could perhaps call the more exotic interpretive approaches that Lord Panic puts forward. And they come from three areas of the law. One is patent law, secondly, contract law, and then thirdly, public law. And he prays in aid principles which he says you find in other areas where documents are construed, and that those ought to inform the court's approach to construing this specification.
Yes.
Now, it's important to bear in mind why he says, or when he says, those approaches come into play. As I understand him, he is saying that one adopts those approaches when there's an ambiguity. And then he says the ambiguity leads to a potential invalidity. And therefore the court should strain to construe the document, here a patent specification, in a way which saves the document or saves the claim. Now, before one gets to the specific of those particular areas of law, our overall submission is that it would be illegitimate for this court, or indeed any court, applying the patent convention, to adopt those more exotic approaches, because the start and end of the domestic court's obligations and the way in which it should be interpreting patents is what one sees in section 125.3 of the Act, which requires one to adopt the protocol on the interpretation of Article 69. And as I've said earlier in my introduction, in English law at least, Article 69 represents the purposive approach to construction. So none of those exotic approaches can be adopted. The second point to make, my lord, and this is reflected in one of the American cases I'm going to show you very, very briefly, is that one has to keep the issues of construction and validity separate. On the approach that the appellants adopt, one doesn't know what the correct construction is until you've had a trial on validity. That can't be right. And that problem was identified very clearly in an American case, because my learned friends say, well, adopt the American approach, where they do adopt this construction of trying to save the document. And in the interest of time, perhaps I can just show you in our written case at MS page 477. We've set out at 229, a section on the international approach that's relied upon by the appellants. (229) Roman 1 refer to the US position, and we quote what what we submit the position is. So Warner-Lambert cites two 19th century Supreme Court cases in support of its proposition, Turrell and Klein. But those cases state that the maxim only applies if practicable, or if this can be done consistently with the language, and the more recent decisions have been more circumspect. Now, what's quite important, I'd ask the court to please read the quotation at the top of page 478. But the part I'd ask you to underline is the very last sentence, which is that, and this is exactly what the appellant's approach leads to, where it says you can't adopt this approach because otherwise the construing court has to put the validity cart before the claim construction horse.
Yes, but they are accepting the principle, and a moment ago you were submitting that the ordinary principles of construction apply.
Well,
Why don't they apply in this area? The principle would have no application if one took your submission that because there might be arguments which had to go to trial about whether something was valid, it was impossible to apply the principle. The principle applies where by definition there is a problem about validity on the face of the document, which a skilled person ought to be able to identify. Then consider whether the document really means itself to be invalid,
well,
having regard to the fact that it's clearly not set about, for example, rendering the claims plausible across the full width.
well, Lord has our primary submission, which is none of these principles apply at all. If one looks at the US position, this is all I'm dealing with, is that it's actually quite confined, which is, first of all,
Yes.
it's
Principle
absolutely
is generally quite confined, isn't it? I mean,
Indeed.
nobody suggests this is a way of running riot over the obvious meaning of the contract.
But the point I wanted to emphasise is the cart and the horse point, which is what's happened in this case. My Lord has posited, in some ways, an easy example, which is if one can look at the specification and say, well, obviously, if that's what it means, it's invalid. But that's not what happened in this case. What happened in this case is that we had a trial. In the course of the trial, after the evidence has been led, the appellants come up with this construction. So, in a sense, this case is a kind of test of that principle.
Is what you're saying really that it says all the difference in the world between construing a technical document like this from the armchair of a person skilled in the art and construing it from the armchair of a person who's sat watching a 2-week trial.
Indeed.
In particular, a trial as to validity with all sorts of expert evidence deployed both ways.
Absolutely. So that's just a US case, but then Lord Panic also relies upon a 19th century British case, which is the Parkinson case, and one again needs to look at.
Where do we find that in your case here somewhere? Parkinson case.
I'm going to take my Lord to that case because it's important to deal with it in our written case. I'm just going to find it. It's at MS 467, paragraph 202. And there we've set out what was said by Lord Justice Sedley. And if I could ask the court, there are actually further passages in that case, which Lord Panic didn't show, my lords, which are quite important. The case itself is at volume 1 of the authorities, and it's MS page 1529. And the question was, where you've got an ambiguous patent, what's the correct approach to construction? And one sees at 98 and following, which which I won't read, Lord Justice Sedley dealing with the Parkinson and Simon case. But the reason that he rejects that as the approach is the protocol. Going to page 103 at 1531. And in particular, this is a crucial point which the appellants don't really address, and it's what one could call the public notice function of patents, which is that if one looks at the protocol, which is cited just above paragraph 103 at 1531, the last four lines say, on the contrary, this is the interpretation of patents, on the contrary, it is to be interpreted as defining a position between these extremes which combines a fair protection for the patentee with a reasonable degree of certainty for third parties. So what Lord Justice Sedley is there saying is that once you start going beyond the ordinary meaning of language and adopt principles or doctrines such as generous interpretation in cases of ambiguity, you undermine the requirements of Article 69 of the Protocol. But I should also identify that, in fact, this is the only English case which comes near suggesting that there is this principle. But in fact, if one looks at that case, and one should look at it very, very quickly, cases in volume 4, divider 38. Which is at MS 2780. This is a case about a patent for a form of sieve, where ultimately the patent is held invalid, and the House of Lords also hold the patent invalid. And it's at page 411 under line 20 at 2788 that we have these observations from Lord Davy that Lord Panic relies upon. But it's interesting that no other member of the House of Lords touches on this subject. But one knows, because of the record of the argument, that the Lord Chancellor was having none of it. Because one goes back to 2783, and one, certainly in these old reports, it's quite helpful to see the reporter referring to interjections by the judges. And if one goes to the bottom of the page, at 2783, we have a reference to the Lord Chancellor right at the bottom. It says, the Lord Chancellor, I have always protested against any such principle. The English language must be construed according to the ordinary meaning of the words and sentences. If there be an ambiguity, that is another matter. But one then doesn't go on to see any endorsement of what Lord Davy is there saying by the other judges. And just going back to our written case at page 468, MS 468, Lord Panic did not take you to these particular cases, but neither of those cases, these are cases in their written case, Langston and Langston, which is a case concerning a will, and then Kiri and Amgen, where there's an offhand comment by Mr. Justice Neuberger. Neither of those, as a matter of English law, support the existence of any such principle as regards patents. The next area of law that's relied upon as being a cognate area, relied upon particularly by Lord Panic, is public law. He says, in public law, one regularly sees the courts construing legislation, both primary and delegated legislation, in a way to save it, particularly delegated legislation. But in a sense, there's a very easy answer there to that example, which is, as the court will be aware, the reason that the courts adopt that principle of construction, as exemplified by Raymond and Honey, and indeed more recently by the judgment of Lord Hoffman in Sims, is that when one has fundamental human rights in play, courts will not readily interpret legislation in a way which takes away or cuts down those rights. And that leads to a conforming interpretation. That's the principle operating there. Now, one steps back and said, how can that apply in the context of patents? There's no analogy at all.
But is the principle outrage Magis Valiat in relation to public documents, does it come into our law only after the incorporation of human rights?
Well, it certainly existed prior to that. So Raymond and Honey is a pre-Human Rights Act.
Yes, so...
And there was a common law right at issue there. So it applies. I should have been clearer. My Lord's quite right to say that. So one can have fundamental human rights that exist either under the convention or under common law. And the principle is one doesn't interpret legislation in a way which will cut down those words, cut down those rights. But one asks, that has no application in the case of patents.
Well, there's the same dilemma that arises in patent law doesn't arise in public law. If you limit the power of the minister to do whatever it is, there isn't a knock-on effect on anything else. You are simply dwindling the number of things he can do. The context in which this arises in patent law is quite different, and that you may, by limiting the claim, enlarge the scope of the monopoly by comparison with what it would have if the claim was larger and the patent thereby void. The whole trade-off, which makes patent law a sui generis area, just doesn't arise in any other field.
I would respectfully agree with that, my Lord.
In the Victorian case law, Lord Justice Sedley goes into it in some detail in the Smith-Klein-Beecham case, and I've been looking at MS 1529,
Yes, I have.
where he cites Sir George Jessel. And the point that seems to have been important at that time was that there was no possibility of amending.
I'm going to come to that, which is that one sees, I'm grateful for my Lord for raising it now, which is that at the end of paragraph 99 on MS 1529, in the quotation from the judgment of the Master of the Rolls, in the Skate case, Plimpton and Spiller, the reason motivating the potential existence of this principle of validating interpretation was that at that point in time there was no power to amend the specification. Does the want of a power to amend the specification of an invention in a trying point often prevents an excellent and useful thing? And that's important, my Lord, for a point that we did make in our case, which is that one doesn't have in the case of interpreting a contract, for example, or indeed interpreting legislation. One can't say to the person who drafted it, you can go and amend it. So the fact that there is a power to amend, which we're going to come on to consider as the abuse part of the appeal, is also a strong indication that this court should not, as a matter of policy, endorse any principle of validating construction. So just going back to then those other areas of the law, the overarching submissions we make, first of all, you can't apply them because of the protocol. Secondly, the policy considerations are fundamentally different. I should also echo a point I believe that was made by one of the members of the court yesterday, which is that the reason that the court tries in a contract case, a pure contract case, to make things workable, is that unlike a patent, in a contract case, the court starts from the position that the parties have made a bargain which they want the courts to enforce. By contrast, in a patent case, as described by Lord Hoffman in the Kiran Amjan case, it's a unitary document. In other words, a one-sided statement by an individual as to what he considers the scope of his monopoly to be. Well, I was going to turn next then, those are our submissions on construction. I was going to turn next to the issue of abuse of process, which is a separate part of the case. I'm happy to start on that now or commence at 10 o'clock tomorrow morning.
Well, why don't you give it a start? We've got
Certainly, my lord. So there are
7 or 8 minutes.
Okay. We've dealt with the abuse case in some detail in our reply written case, which begins at page 394 and goes on for some time. But there are 3 aspects relied upon, 3 errors of law, which Lord Panic relies upon in relation to the abuse of process decisions of Mr. Justice Arnold and the Court of Appeal. The first is that the court failed to apply Article 138 of the European Patent Convention. The second is what's called the Section 63 amendment point. And the third is that on the facts, the end result, in other words, the denial of permission to amend, was a disproportionate outcome. And just dealing very quickly then with the first point for developing the submission to Article 138, what I'm going to show, my lords, tomorrow morning is that the arguments based on Article 138 are misconceived for a very simple reason, which is Article 138 of the Patent Convention as amended only requires of member states one thing, which is that in their domestic law, they must have a process to amend patents. And prior to the amendments to Article 138, some member states did not have a process to amend patents. And all that Article 138 did was made it mandatory for all member states. However, prior to Article 138.3 as amended, English law had a power to amend patents for many years. And the submission of Lord Panic appears to be that Article 138.3 changed everything and somehow affected the procedural autonomy of member states in relation to the way they manage their civil litigation. In fact, all that Article 138.3 as amended did was require member states to provide a power to amend. It did not touch upon the procedural autonomy of member states to decide how to manage litigation. Now, that is a conclusion reached by Lord Justice Jacob and, interestingly, independently, it is a conclusion reached by the Supreme Court of the Netherlands. And I'm going to show you that case we looked at briefly yesterday, but it's actually very important, because as recently as last September, the highest court in the Netherlands considered exactly this issue. So in Dutch civil procedure, there were certain procedural requirements governing amendments. And a case reached the Dutch Supreme Court on the basis of an argument, very similar to the argument made by Lord Pannick here, which is that because those procedural requirements were strict and basically said there is a fixed timetable, and in the interests of procedural economy, you've got to stick to that timetable, the Dutch Supreme Court said that we weren't going to allow this person to amend. There was a direct attack on that rule of Dutch civil procedure. And the Dutch Supreme Courts looked at Article 138, looked at the procedure in England and in Germany, and said, as a matter of state practice, Article 138 does not encroach upon the procedural autonomy of member states to manage their own proceedings.
And it did so, as I recall, after looking at this very case in the Court of Appeal.
So what happened was that the Advocate General, whose opinion we'll look at tomorrow, went in detail. You only looked at, yesterday, Lord Pannick took you to what he said about Germany. He didn't take you to what the Advocate General had said about the UK procedure.
It was
just immediately underneath.
Indeed.
Yes.
So he referred, without any disagreement to what was going on, to what one could perhaps call the Jacob approach, which one sees in the Nokia and Nicken cases, and then the approach of Mr. Justice Arnold and the Court of Appeal in this case, and concludes, based on that and the German case law, that the procedural autonomy of member states to manage proceedings is not affected by Article 138. Therefore, this whole submission is completely missing the target.
And there's no court which can or could give an interpretation at a European level or of the convention.
Indeed, what happens, we'll look at, and I raised
Look at lots of
because the Lord
nationals.
raised this issue yesterday, I think, in response to what Mr. Mitchison was saying. Mr. Mitchison, I think, referred in passing to the Vienna Convention on the Law of Treaties.
Yeah.
One sees in the Advocate General's opinion, he says, this is the treaty provision, Article 138. How am I going to... I'm going to look at the language, but I'm also going to look at state practice under the Vienna Convention. He looks at state practice, namely, the only state practice that exists, he can find, is Germany and the UK. And he says, I take from that state practice that Article 138 does not seek to limit the procedural autonomy of member states. So there's actually a very simple answer to the entirety of this first argument based on Article 138, which is it's just irrelevant. Because member states can say, of course you can amend. We do that in the UK. It's been possible for many years. But you must do it in a way which we regard as procedurally fair. And Article 138.3 doesn't seek to govern the rules because they differ in different member states. So it's now 4 o'clock, but I'll come back to show you that case tomorrow in more detail.
We'll look forward to your submissions at 10 o'clock tomorrow morning.